Now back to Inside Real Estate. Here's Mike the Realtor.
Hey folks, we are back. Website, InsideRealEstateRadio.com. Check out the website, InsideRealEstateRadio.com. Hey, now it's time to do a little bit of legal analysis. We've got our legal expert, Perry Cockerell, here in the studio. His website, PerryJCockerell.com, PerryJCockerell.com, and also the author of A Private War. And by the way, A Private War has also been separated out into a 5-part series, and the very first volume has just been released on Amazon, so check it out. A Private War on Amazon.com, and actually he's working on the sequel as well. So very cool. Perry, how are we doing today?
Doing fine. Thank you, Mike. Nice to see you.
Good to see you. And, we alluded to earlier in the show how important title insurance is going to be. And so let's kind of get into some of that and talk about, a little bit of the case law that is why it's so important.
I do want to mention that, of course, if you have a loan from a lender, title insurance is going to be required anyway. And you see it just in most transactions. I can't even think of one where they do not take it out for one reason or another, but
pretty rare, yeah.
And things come up, but there's some types of transactions that you really will be glad that you have that, because there's some that are not fixable, and there's just going to be a title insurance policy that'll pay a claim in the event that title fails. And there's a lot of things they can do after a claim's made. The company will hire an attorney that represents you in court, and they do their best to cure that title defect. And that's what I do for a large amount of cases for a number of title insurance companies. But some of these are just transactions that they're not fixable, and they're ultimately settled out of court in a way that's satisfactory to all the parties. And I've just been through some experiences like this in the past, and it's even in cases where the seller or the buyer, rather, and even the lender, I'm representing both of them, have basically done everything they're required to do, and the title company, for one reason or another, fails to pick up the fact that there's a real defect going on here. And so that's what I've seen. And what the concept I'm going to bring up today is receivership. It sounds boring, but it isn't.
Right.
It reminds me that the U.S. Senator John Tower, they used to say his name is Tower, but he don't. But receivership sounds boring. If you're going to go to sleep, let me tell you, it is not.
It is not. And you should listen to this, because this is a situation that, got some folks in some very desperate times because of, this type of issue. And, look, title insurance is going to cover you for those title defects that the title company does not pick up. And in so many cases, the title company only researches the county in which the property exists. And oftentimes things are processed in other counties, which can cause issues. Look, folks, there are so many things that can go on when buying a property, and any type of property. And so that's why you want to be covered. So let's talk about this receivership.
That's what's seems a real problem. But the Supreme Court answered this question years ago in the 70s, and that's just where a receiver was appointed in a case. It was under a will, and the property was foreclosed on a couple of months after the receiver was appointed, and there was no what they call lis pendens filed in the county where the property was located, and the Supreme Court said the receiver doesn't have to do that. Now that's why it wasn't picked up, or in other cases that's why it's not picked up at the closing. This concept applies even if there's no indication of it of record. And that sale is void. In other words, it can't be fixed. So typically it's settled out of court. And this is why you would need title insurance. It picks up that unknown quantity like that. And I've just been through several of these where this happened, and the seller is just at a loss. What did we do wrong? You didn't do anything wrong. What did the title company do wrong? Well, they didn't pick it up. And for particular ones I've seen, there were actually indications of record on those. So this is very unusual. But here's where you see it, and this is what's vogue, and that's why I have like a handful of cases just within the last 2 months. Total 1, 2, 3, 4. We're not going to go all of them, but I'm going to tell you where it's coming into play. Is a lot of people who sell property actually have maybe a judgment debtor they owe somebody some money and that judgment's been reduced by a court. And what judgment creditors are doing is they're going to court and they're asking for the court to appoint a receiver. And the receiver can take all the judgment debtor's non-exempt assets and sell it. Sounds good for the judgment creditor.
Mm-hmm.
The downside is that the cost of that receiver, if it's a lawyer, can what they call spin out of control. And that attorney will charge by the hour and can spend extraordinary amounts of time going after property which he's not even certain exists. But when he does, then you're really stuck. You can't sell the property until you satisfy this receiver claim. And so the other area where you see it is in divorce. The parties are going through divorce. They want to prevent the home from being foreclosed on because they can't pay the mortgage. And you see the court appoint a receiver there. The other is under a will that has a trust, and for some reason or another, the trustee is doing improper activities such as conveying property to somebody that's not under the will. Then a beneficiary can have a receiver appointed. The other is where partners own property jointly. Another is where, let's say, a bank is foreclosing on a lien, and you see just hundreds of foreclosures at the courthouse steps. They also have a right to have a receiver appointed and might do that in some very sophisticated cases. Though they do that in cases where you have large real estate projects that might be failing, such as apartment complex, construction projects. They'll put those under receivership. But interestingly, what is not available under the law and is, let's say you're a debtor under your home equity loan or your residential mortgage. You don't have a right to just, if you're under foreclosure, you don't have a right to have a receiver appointed, although it would make sense. It could stop that foreclosure.
Stop foreclosure, yeah.
It could protect your equity, and that remedy's not available in the law. It's been carefully crafted out of there. It's only available for the lender, and the lender's not going to do that because the receiver costs a lot of money.
Mm-hmm.
I think it might be something to look into because there's so many foreclosures of home equity loans going on. There's so many foreclosures of home mortgages. If the mortgagor, being the borrower, could just ask the court to appoint a receiver, that would stop that foreclosure, protect the equity if there's equity.
Right.
And then that property could be sold. Rather than appointing an attorney to sell that property, what they should do is appoint a real estate agent. And that's what I do in these cases with receivers, is that you might as well get a real estate agent. They know what the market is. A lawyer's not going to.
Mm-hmm.
He or she is going to charge a fee, which is the typical commission fee, which we already know it is because it's in a contract.
Right.
Whereas an attorney is going to keep an hourly rate.
Billable hours.
And it could just, as one judge said in one case, spin out of control.
Right.
Some of the judges do not like receivership, and they will not appoint them. Because of that problem, it creates, in effect, a judicial officer out there who has immunity and can just escalate the costs of the case beyond your imagination. So the other option is if someone is being foreclosed on under their home equity loan or their residential, really all they can do is reinstate it, work with the lender, or they typically go file bankruptcy, Chapter 13 for the most part, if they want to keep that mortgage. But just imagine if there was a scenario under the law that allows you, as the mortgagor, to file a proceeding to having a receiver appointed, nothing more than a real estate agent. That would stop that foreclosure. I'm sure you see some resistance to that
Right.
by the financial industry because that could run up the costs of the sale. But anyway,
But it would be consumer friendly because it would, help save any potential equity, in the property. I mean, if they really are underwater. And so it would, you're right, there would be a simpler process to doing this versus going through what the lenders currently do.
I think so. I'm actually going to contact one of the state senators, maybe both of them, and just propose this. I went through the receivership statute, noticed where the ability to get a receiver was limited to the mortgagee, the lender rather. Just needs to add a word, mortgagor. And I'm certain that they've been through this years past, and there was probably resistance to that.
Mm-hmm.
And anyway, where it's important is sometimes you just don't know that your seller is under receivership. And in this particular case, the one I handled, the seller just basically lied. They signed they signed a document that said it wasn't under receivership. And I'm just amazed that, as you mentioned, as you remember last month, I showed you 3 fraudulent transfer cases. The legislature's also said that if a sale is a fraudulent purchase like that, you can have a receiver appointed to set aside that fraudulent sale. But you'd just be amazed. And so I have here, and I won't go through the cases, but here's 4 cases in the last 2 months where a receiver was appointed in a divorce case, a business case, a state case, and 2 judgment creditor cases. One of the complaints on appeal was that, wait a minute, we don't want this receiver. We can just have the sheriff sell the property, and he doesn't take his commissions somewhat like a realtor. Why do we want to pay this huge lawyer fee? And so that's a big downside complaint to that. So bottom line, how do you protect yourself on a case like that? You probably cannot. If your title company can't pick it up, I'd be very surprised if you're going to pick it up unless you just have a lot of independent knowledge about the seller. And that is one of the benefits of having a title insurance, because some of these properties are very valuable. And if you didn't have that, you would not be able to sustain the costs of trying to undo this or protect yourself in a case like that.
Yeah. When it comes to receivership, it's something that you may not, your agent, if you're using a real estate agent, and then the title company. And the title company, they have processing plants, and that's all they do is just process title work. I mean, this is their job, and they do a thorough job. They do a very good, very thorough job. A gazillion times out of, almost a gazillion. But there are those times where they do miss it. And in those cases, it's so important that you have it. And like you say, if you've got a mortgage on the property, it's going to be mandatory, so it's not really your choice. But if you buy a property cash out, and you're thinking, well, I don't want to do that. Yeah, especially if you buy the property cash out because you're putting all that equity into it.
I would like to know what people think. So if you get a chance to go to my website or see the phone number, I would like someone to give me some feedback. Call or post a note. What do you think if the mortgagor, that's the borrower, that's you. Let's say you get down, you can't pay your mortgage, you're going through a divorce, something happens, you want to protect that equity. What do you think about being able to ask for a receiver, which is nothing more than a real estate agent? If you think about it, the bank forecloses on the property. What do? They eventually sell it. What do they give it to a real estate agent. They sell it at some point. Why not sell it right up front if there's equity, that is? Right. And protect it right there. I just think that would be and think how many bankruptcies people would not have to file Chapter 13. Principally, they're filing because they can't keep their mortgage current. So imagine how many bankruptcies that would avoid if people could just limit the issue to that piece of property and then not having to expose their entire.
And it would get rid of the potential loss for liquidity that that owner has. So.
Certainly.
I think that would be great. Well, go to perryjcockerell.com, perryjcockerell.com, connect with Perry, and give us your feedback on that. Hey, folks, we're back in 2 weeks from now. We're not coming in this next week for Thanksgiving. We'll be back the next week, so tune in for us then, 8 to 9, almost every single Sunday. InsideRealEstateRadio.com is the website. And, hey, folks, have a great Thanksgiving. We're out of here.